across the road.
So it's an interesting one because we often have this debate in practice, especially when it comes to commercial properties and the use of a property. So this particular question is around a specific tenant that has retail space. And across the street, there's a development that's being undertaken. And this development is hindering or hampering to a certain degree access to the premises. And this is presumably because maybe clients can't get in or something along those lines. So obviously, as usual, details are somewhat vague. But Nick, if you can maybe cover what the tenant in these circumstances can actually do. Is this a breach by the landlord or some kind of issue? How does the tenant enforce their rights if this actually does hinder their use of the property?
Perfect. So just to go back to the very start, the basis of a lease agreement. What a lease agreement is an agreement between two parties that one party is going to give the undisturbed use and enjoyment of a thing, and the other party pays consideration, which we call rental, for the use and enjoyment of that particular thing. So the one party's fundamental duty in terms of a lease agreement is to provide the undisturbed use and enjoyment of something. Okay, in property law, we're obviously doing properties, but you can rent many different things in law. But what is the absolute requirement? The base requirement is the undisturbed use and enjoyment of that thing. And that goes on to basically reason that if you lease something, but the undisturbed use and enjoyment of that thing is somehow interrupted, you actually no longer have a lease agreement. So you can't have a lease of a thing that someone can't actually use and enjoy for their own purposes. That seems self-evident, but it's important to know for the purposes of legally, what are the ground stones that are required for a lease agreement to exist. So where a lease agreement is affected to such an extent that someone does not have use and enjoyment anymore, you don't have a lease anymore. And this in law is what we call impossibility of performance. So you reach a point where it is no longer possible to lease a thing, and so a lease agreement cannot exist. The best way to think about this is if you lease a property and that property is destroyed for whatever particular reason, you cannot continue to have a lease agreement. The landlord cannot expect to continue to receive rental, and the tenant obviously can't expect to continue to use and enjoy that particular premises because it no longer exists. Now, that's a very clean sort of point in the argument, and that's very rare that that sort of thing happens, okay? It's very rare that a proper building just falls down or disappears in any particular way. But there are degrees above that where use and enjoyment of a particular premises is affected. Okay, so if maybe you don't lose the whole building, maybe a proportion of the building is not usable for whatever particular thing, or maybe you can't use the property for a specific purpose that it was intended for whatever particular reason. And in those circumstances, the question now arises, well, to what extent and what happens when there's a diminished use and enjoyment of a particular property? And that will depend entirely on what that amount of diminished use is. Now, lawyers have obviously got very clever. We've drafted lovely lease agreements that are existing in law. And generally what will happen is if you have a substantive lease agreement, that lease agreement is going to point out exactly what happens in the particular circumstances. And it's going to set out, what do you do? What is the remuneration? Which might be payable, or reduction in the remuneration which is due to the landlord in the circumstances. So the first point is you have to be very careful and have a look at your lease agreement to see whether that's already been dealt with and what does your lease agreement say. Often these lease agreements are also going to give time periods. So they're going to say if there's an extended failure to be able to use and enjoy the thing, then there will be a right of a party to cancel with or without a damage component which is attached to that. So that's all going to be part of the lease agreement. What's important in this particular question that we've been asked is, this is not per se a diminishment of the use and enjoyment of the property in question. It's more of a diminishment of the means of access to the property. So as we understand the question, there's a retail center across the road is a development, and that development is now to whatever degree affecting the access to the retail center in the circumstances. And so what's interesting about this particular question is it's not per se a diminishment of the use and enjoyment of the premises itself. It is merely a means of access. And what responsibility does the landlord have in this particular question? Now, in our question specifically, what our wrote in was, can they consider that the building has been damaged or destroyed, which would equate to a reduction in the rental payable? So, as I pointed out earlier, we've got very clever clauses, and there are also clauses within many lease agreements, and in particular, commercial, retail, industrial lease agreements that say, in the event that the property is damaged or destroyed in a certain percentage, the tenants can expect a reduced rental payable. Okay, that seems obvious. If you rent a space and 50% of it gets destroyed, you can continue renting the 50% that isn't destroyed, but you would imagine that there would be a commensurate 50% reduction in the rental in the circumstances. And that is what they are asking in this particular question. Is this a circumstance where that provision can be invoked? But my submission on this is it's not a true circumstance where there's a damage or destruction to the premises, because the premises itself is actually fine. This is a question of means of access by virtue of some external development that is happening on the particular premises in the circumstances. So the question that wrote in, no, you can't deem this as a damage or destruction to the premises, which would entitle a damage reduction. Okay, and to be honest, when I look at this particular question, I don't even think that this would be a circumstance where you could expect the landlord to do a reduction in their particular rental. Okay, to extend the means of access to a particular property that is being affected by a third party to a landlord, okay, seems to go a bit far for me. So what I'm saying is, I don't think you can expect the landlord to take a reduced rental as a result of someone else in the area doing a development in the circumstances. So there may be circumstances where the landlord might have a responsibility. So for instance, if they have warranted access by means of a particular point on the premises and that is affected, then yes, there might be a responsibility in respect of the landlord. But unfortunately, in these circumstances, I don't think you can hold the landlord liable and expect a reduction of the landlord's compensation by means of rental, because there is an effect by a third party on the outside of the particular premises.
Absolutely. Yeah, I totally agree. Awesome.
Perfect.
Thanks so much,
And that brings us to the end of today. Thank you, Bruno.
See you next week.
We'll see you next week.
Cheers.
Cheers.